So I'm talking today about the reliability of the mineral appraisal report and what I've called the new world of appraisal review, which involves some changes in USPAP. Let's see, how do I advance this? Is it this one?
I believe it's that one.
There we go. Okay. So today's discussion is going to be, first of all, what is a review? Understanding what you've bought in an appraisal or consulting assignment, or report, I should say, and my observations as a reviewer of fatal or near fatal flaws that I have seen in appraisal and consulting reports. My comments today are intended primarily for the users of mineral appraisal reports, that is, litigators of value of minerals in place, lenders on minerals in place, buyers and sellers of minerals in place, those involved in tax disputes on minerals in place. My comments are secondarily for my fellow practitioners in this field, and this is a bit of a departure. In my previous presentations in this forum, I have presented technical material for the assistance of my colleagues. In this case, I'm talking mainly to the users, the people who buy our products. An appraisal or consulting report is a kind of ammunition. And you buy this ammunition, this appraisal, to argue high-dollar confrontations. Usually there are millions of dollars at stake in the dispute. There are tens of thousands invested in this ammunition, as I call it. And that is the appraisal you bought. And usually in litigation, there's many thousands more invested in lawyers and other expert witnesses. So do you really want cheap ammunition? So I couldn't resist this living up in the mountains of central Idaho. This caught my eye. Don't buy Lester's ammunition. Here's Lester's ammunition. It says America's cheapest ammunition, and at the bottom it says it usually works. And we see this bear who has apparently just either eaten some poor bloke or pushed him off the cliff, and there you see his hat going out into space and his shirt tail in the bear's mouth. But most importantly, you see his rifle laying there on the trail, which presumably has Lester's ammunition in it. So what I'd like to do is be sure that you don't become that bloke. So there are two major uses for reviews. First, for a report that you've bought, and that it's as a risk management tool, finding Lester's ammunition before the opposition finds it. Or, maybe or, for the opposition's report, to assist in building counter-arguments, and that is to find Lester's ammunition in the opposition's report and use it to your advantage. To get a common ground here, let's start with the definition of a review. A review is the act, and this is from a Uniform Standards of Professional Appraisal Practice definition, USPAP, you see at the bottom there. And a review is the act or process of developing and communicating an opinion about the quality of another appraiser's work that was performed as part of an appraisal or appraisal review assignment, and I have parenthetically added there, or a consulting assignment. I've underlined quality of another appraiser's work because a review is typically not a reappraisal unless you ask it to be. If you'd like it, if you as a user of an appraisal would like your reviewer to do a second opinion on the value, that's fine. It's usually not required. But most importantly, a review is not an attack on the other appraiser. It sounds a little bit like rebuttal, so let's look at what Black's Law Dictionary tells us about rebuttal. It's the introduction of rebutting evidence, the showing of statements of the witness as to what occurred are not true, evidence given to explain, repel, counteract, or disprove facts and evidence by the adverse party. And I'd like to clarify that just a little bit by just contrasting those two things, the difference between a rebuttal and a review. First of all, similarity, both are used in adversarial settings, but the rebuttal has a strong connotation of advocacy. and it may include a discredit to the other appraiser. It may introduce new facts. The review is impartial as to value, again, unless you request you as a user request a new value. And it should not discredit the other appraiser, and it considers only the facts in the other appraiser's report. So a review can be used as a rebuttal, or at least the basis of a rebuttal, but usually not the reverse. So to avoid Lester's ammunition in your reports and to use it to your advantage in your opponent's report, what does Lester's ammunition really look like? We can't even tell in this poster because it's in the rifle and you can't even see it. So what does it look like in an appraisal report? To try to point that out a little bit, I'd like to share with you some of my observations as a reviewer of Lester's ammunition that I have found in reports. These observations are from my own desk. They are not invented. They're from real reports. They're not from a textbook. The common thread that I find running through all of them are one of two things. Either there's strength in mining geology but weakness in appraisal theory, or there's strength in appraisal theory but weakness in mining geology. Remember that mineral property appraisal is a dual disciplinary discipline, and the mineral property appraiser needs to be totally comfortable in both mining geology, petroleum geology, mining engineering, petroleum engineering, and appraisal. You can't be strong in one and fake the other, or it will come out very quickly. First example is confusion on exactly what is to be appraised. That sounds kind of strange if you're not around appraisals much, but it can be somewhat elusive. And it's the single most common flaw that I find in my review work. It results in capitalizing net income, and we're talking just about eminent domain here, capitalizing net income from operations if the assignment calls for valuing the royalty income stream. And I'll come back to that in just a minute in the next slide. What it does is it captures the value of personal property, intellectual property, and the entire business value. But in an eminent domain case, normally that's not what has been taken. What has been taken is the real property. It usually results in a substantial overstatement of value, overstatement of the value if only real property is what was to be valued in the first place. These reports are typically weak in appraisal theory and particularly weak in eminent domain appraisal theory. So to continue that thought just a little bit, I'd like to show you a kind of a watershed on the value of real property, whether it's the value of real property that's required or the value of real property plus the going concern that's required. So here are 5 different demands for an appraisal. First, let's talk about eminent domain for a minute. If it's an eminent domain action, normally it involves only the real property. So the proper appraisal technique is usually the present value of the royalty income. If the purpose of the appraisal is asset-based lending, that usually involves collateralizing real property only, not the business. And so that, like the first one, usually involves present value of royalty income. If it's the acquisition or joint venture of an operating mine, that often requires real property plus the going concern. And the usual way of doing that is the present value of the net operating income. If it's divestiture of an operating mine, just like that's the other one in reverse, the previous one in reverse, often involves real property and a going concern value, and that's usually best done by present value of the net operating income. If it's an ad valorem tax dispute, ad valorem taxes normally apply only to real property, and so the best way to measure that usually is the present value of the royalty income. Here's another example. Confusion on nominal and constant dollars. First thing I sometimes see is the failure to disclose in the report whether the appraisal is conducted in constant or nominal dollars. Fortunately, I'm seeing less and less of that in my review work. The appraisers are wising up to that. But what I still see a lot of is using nominal dollar discount rate in a constant dollar model, or vice versa. Those two things need to be aligned with each other, If I remember correctly, about 10 years ago in this forum, I think we were meeting in St. Louis that year, I presented a paper on how to make that adjustment. I showed two ways of doing that adjustment. But when either of these flaws shows up in a report, it's usually a report that is strong in mining but weak in appraisal theory. Here's another one. Confusion on the definition of market value. Failure to recognize the difference between market value and investment value. The issue in market value is due diligence on what the typical buyer would do. The issue in investment value is what a particular buyer or seller would do, and quite often that degenerates down into what the owner of the property is doing or would like to do. Usually in appraisal, you need market value, not investment value. Sometimes you do need investment value, but usually what happens in these reports is the appraiser will define market value, and there's a number of good definitions for market value. They all say about the same thing. And they will say they're going to find market value, then they proceed to talk about what the owner would do or what a particular buyer would do, and never even mention investment value, but that's what they're doing. So these appraisals are typically strong in binding, but weak in appraisal theory. Another example, confusion on before federal income tax, BFIT, and after federal income tax, AFIT value. BFIT comes closer to reaching market value because BFIT does not model any particular buyer's tax situation. AFIT inherently models some buyer's tax situation, so the value found more closely resembles investment value than market value when AFIT is done. BFIT values the property as a standalone without the distortions of tax interpretation. AFIT creates a conflict with the cost approach, which has no FIT implications. And I've parenthetically put in there, take this one home. This is right off of my desk. You won't find this in any textbook. And the reason you won't find it in a textbook is when capitalization theory is taught in all the classes that we take to be appraisers, and those are usually, they're almost always commercial real estate appraisal classes. AFIT value in commercial real estate is unheard of. It's universally done on a before federal income tax basis. So what happens is it's taught without ever considering the possible conflict if you do AFIT, conflict with the cost approach. Remember, the cost approach is replacement value less accrued depreciation. Only that's not IRS depreciation. It's the combination of the 5 forms of depreciation we recognize in appraisal. It has nothing to do with the artificial 5-year, 10-year property. So there's no federal income tax implication in your cost approach. And there is obviously an AFIT income approach, and the two don't reconcile. If they do reconcile, it's because the numbers are so sloppy you can't tell the difference. And that often happens. That's not the appraiser's fault. So that's a good one to remember. Most appraisal work is done on a BFIT basis. Again, these reports are typically strong in mining but weak in appraisal theory. Confusion between a discount rate and a capitalization rate. They are not the same. The correct relationship is the capitalization rate is the discount rate minus delta A, where delta A is the change, plus or minus change, in the anticipated income stream. Therefore, capitalization rate does not equal discount rate unless delta A is 0, which is almost never. That's pretty far in the weeds for the user of an appraisal report. As the user of an appraisal report, you don't need to know that. All you need to do is look for the interchangeable use of those terms in the appraisal report. If you see interchangeable use of those terms, cap rate and discount rate, then your appraiser probably doesn't know this relationship. And anyone who calls himself an appraiser needs to know this relationship. The last one is superadequacy. And this is one a very interesting one that came out of a case that I was involved in, and it was litigated not quite a year ago. It involves an appraiser, a very competent commercial real estate appraiser who was brought into a mining property appraisal and never should have been brought into it, should have declined it but didn't. And it involved the taking of a 24-foot by 20-foot by 2,300-foot adit. And this was a consulting report that the opposing appraiser did. He recognized that the highest and best use of the adit was exploration. It was a drilling platform. I don't know how he recognized that, but he did, and I agreed with him. But exploration does not require an adit of that size. And so that constitutes superadequacy in appraisal speak. Back when I was working underground as a mining geologist, I did all kinds of drilling programs out of 10 by 10 foot adits with haulage trains going on behind me. And we just simply put a two-man drill crew in there and used 5-foot joints and 5-foot core barrel and knocked out a bunch of drilling. So the train, and stopped when the trains were going by, used the trains to haul my core out, and so on. And there's a hot trolley line right there. You don't need a 20 by 24 foot adit to do this. And so that was superadequacy. So the result was an enormously overstated cost approach, as you can imagine. So here's a report that was strong on appraisal theory, except the appraiser was unable to make the application to mining. This appraiser would have recognized superadequacy in an office building in a heartbeat. So what's going on with appraisal now? The former way of doing this was to focus on finding non-compliance with standards 1 and 2. And a lot of old-time reviewers say that they never did do it that way. Maybe they didn't, but plenty of them did. It usually results in a review report that is not very useful. It's legalistic, and further, it puts the appraiser in the position of being judge, jury, and executioner regarding USPAP, and no reviewer should be in that position. So the more current way of doing it is, and then these are not new parameters, but the more current way, the way the Appraisal Institute is teaching it, is to focus on these 5 parameters. Hold the appraisal up to these 5 parameters. That is completeness, accuracy, adequacy, relevance, and reasonableness. And anybody can read the review report and understand the flaws in it if it's done in that way. It's much more user-friendly. So what do you look for in a reviewer? Well, first of all, you want to have complete absence of conflict and bias. The reviewer should have a recognized degree in geology, mining engineering, or petroleum engineering, or the equivalent, and you should ask for it. The reviewer should have extensive formal education and appraisal, minimum 300 hours of classroom and dozens of past examinations. You should ask to see it. And that 300 hours is not something out of my head or out of the air. There's 300 hours required for certified general licensure in all states, all 50 states and 4 territories. And whether your reviewer chooses to carry certified general licensure is another topic. But if your reviewer chooses not to carry certified general licensure, it should not be for lack of education. There should also be formal education in review and some examinations on that. And there should be extensive experience in the subject type being appraised. So finally, my recommendation to anyone buying an appraisal is to have it reviewed, first as a risk management tool for reports that you've purchased, and secondly as a basis for rebuttal in opposing reports. So maybe we have some questions, and maybe I might even have an answer.
Does anyone have any questions for Robert? If you please come around to the microphone. One gentleman coming up
here.
Yes, my name is William Rapier. I'm a professional geologist and a mineral appraiser, but I do mineral appraisals for real estate appraisers, and they use my work in their reports. How do you view that in the circumstance of what you just discussed?
I totally encourage that. I think that's an excellent idea. In my own appraisal work, I do something similar to that. I work with a PE mining engineer on almost every appraisal. If there's anything that resembles production in the mine, and I let him do an engineering report, which then becomes the first addendum in my appraisal report, and I refer to it repeatedly. So I think that's a very good practice.
Thank you.
Are there any other questions? We'd have time for one more. If not, I'd say
Thank you.
Thank you.
Thank you very much.